and turn it over to Ashley Barton-Quast, the 2022 criminal section leader for the Contra Costa Bar Association. Ashley?
Thank you so much, Anne. As Anne said, my name is Ashley Barton-Quast. I am the president of the criminal law section, and I am so excited to welcome everyone to our first MCLE of the year, New Laws for 2022 for Criminal Law Attorneys from our favorite statute decoder, Garrick Byers. Now, I'm sure many of you have attended the prior New Laws events. I see a lot of familiar faces, but for those of you who don't know, Garrick Byers, the statute decoder, is a noted writer, speaker, and litigator in California criminal law. Every year, he web publishes a treatise on new laws and gives many presentations about them. He writes 3 chapters in CEB's California Criminal Law Procedure and Practice. He's spoken at several CEB criminal law webinars. He coordinates and speaks at the California Public Defenders Association annual MCLE activity New Statutes. He's a former president of CPDA and is on their legislative and ethics committee. He's spoken at tens of MCLE activities for CPDA. He's certified by the California State Bar as a criminal law specialist and has recently handled many felony murder resentencing cases under SB 1437, Penal Code Section 1170.95 with the Solano County Public Defender. He's currently a Law Enforcement Auditor 3 with Sonoma County's Independent Office of Law Enforcement Review and Outreach. This is where I would say, let's give him a round of applause, but since I'm the only one that he can hear, I'll give it for everybody else. Other things that I just want to mention to everyone before we get started is that if you have not renewed your membership for the Contra Costa County Bar Association, you need to do so by January 31st. So do it because you don't want to miss out on these great events. Also, while she is not available today, I would like to announce that the criminal law section has a new board member. Danielle Jones has joined as our secretary treasurer, and I look forward to her being present at future events when she can also attend. If anybody has any questions or concerns or ideas for new MCLEs, please don't hesitate to reach out. There's also still one spot on the board if anybody is interested. So with that, I will turn it over to Garrick and assure everyone that I will get you good copies of the beautiful PowerPoint presentation we're about to see and a incredible bout of written materials. It's 109 pages of just exquisite text. So turning it over to Garrick, thank you.
Well, thank you very much, Ashley, and I'm very pleased to be here. Good morning, everybody, or good afternoon, everybody. Now I should be screen sharing. Does everybody see my slides, I hope? Okay, so let's just start off.
I'm so sorry, Garrick. I completely forgot the one other thing that we said we were going to do. If anybody has any questions or comments during Garrick's presentation, he'd like to take those questions as they come. So put them directly in chat and I will keep an eye on that so then I can pop in, much like I just did, and interrupt his excellent presentation.
Okay, wonderful. So great. So we're screen sharing, I hope, and everybody can see my presentation. So we're starting in. Today's goals are to tell you about some of the major new laws this year. There is an extra large number this year. What I'm doing today is a memory jogger. You're not going to remember all the details of these. I'm going to go a mile a minute. But as you meet these during the year, well, you say, well, I think the statute decoder talked about that one. I better look it up. So that's what's going on now. This year, many of the important new laws are social justice reforms or other reform laws. Some of them are expanding on previous reforms. There's a couple of important new laws that are really old laws that had delayed operative dates until today. There's a lot of the laws that are complex, have a lot of moving parts, and many of the important new laws are aimed at reducing time in custody, reducing the prison population. So we have a trivia question this year. How many California Supreme Court justices are likely to be on the November 2022 ballot? I have a hint. There has not been this many on the ballot since 1930, and the answer will come at the end of today's presentation. And about an hour from now, I will stay afterwards and answer questions as well, but I'm also going to answer questions as they go, as long as they get read to me or told to me. So here's the first one this year. 17 administrative fees have been repealed. This is a continuation law. It's AB 177. Oh, you can see that at the top right, top left of my slide. There's a list of the affected statutes in PC 1465.9, 1469.5, which we'll go into. So this year, 17 administrative fees have been repealed. For cases that already have those fees as of December 31st, after that, they're uncollectible, they're unenforceable. And if you go to court, you can get the judgment that imposed that fee. That portion of the judgment has to be redone. Many of this year's fees are the 10% or the 15% fee for paying in installments. So one of the amended statutes is PC 1202.4, which is the main restitution statute. So if you look at a list of statutes affected, you'll see that statute's been affected. Well, the only thing that's been affected in the restitution statute is that the fee for paying the restitution fine in installments, I think it was 15%, is repealed this year. So now this, as I said, this is a continuing trend. This is last year, there were 23 administrative fees repealed, many of them big major fees. And you can find a partial list. There were a few government code sections repealed, but you can find a partial list of all of the penal code sections that were repealed are in 1465.9. This section's in the middle of a huge section of statutes, 1464, 1465.1, 0.2, 1466. You'll find it in there. And A lists all of the penal code statutes, administrative fees that were repealed last year. And this year, you'll find this year's list in 1465.9B. And you can see all the sections there. And as Ashley said, you don't have to take notes on those. You're going to get the slides sent out to you. They're also in my written material, but just so you know where to look. And this year, a couple of vehicle code sections, administrative fees have been repealed. So those are going to be in VC 42240. Okay, 4 changes to Penal Code Section 1170. This is the major new law this year. So there's 4 changes. I'm going to talk about each one in a little bit of detail. The most important one of those is that the aggravated sentence cannot be imposed unless the aggravating circumstances are proven to a jury beyond a reasonable doubt, or to a court beyond a reasonable doubt in a court trial, except for prior convictions, which we're going to come to. The second big change is that there's 3 contributing factors that can require the low term. And the third one, there's not too many cases like this, but a juvenile who got a life without possibility of parole sentence may be entitled to a resentencing hearing, maybe to get earlier parole or lower the sentence. And then finally, resentencing has been recodified and really beefed up in a big way, and that's an important one. So let's look at these in some detail. So number 1, proof of trial beyond a reasonable doubt of the aggravating factors is required. If you really have to look up the detailed history on this, you're going to need to look at Section 1.3 of Senate Bill 567. Hopefully you won't have to do that. So those of you who do felony know that when a felony's got 3 possible terms, the lower or mitigated term, the middle term, the upper or the aggravated term, then since 1970, since 2007, the Penal Code has said that when the felony's got 3 possible terms, the court can choose any one of those 3. And the amendment this year says that the court now cannot go above the middle term unless the aggravated terms have been proven to a jury or a court. And that's rewritten 1170 subdivision B 1 and 2. So let's look at those. So B1 says when a judgment of imprisonment is to be imposed and the statute specifies 3 possible terms, the court shall order imposition of a sentence not to exceed the middle term, except as otherwise provided in paragraph 2. Here's paragraph 2. The court may exceed the middle term only when there are circumstances in aggravation of the crime, the underlying facts of which have been either stipulated or been found true beyond a reasonable doubt at trial by the jury or by the court in a court trial. Now, the second part of this is also very important. It says, except where evidence of an aggravating circumstance is admissible to prove or defend against the charged offense or enhancement at trial, or unless it's otherwise provided for by law, then upon request of the defendant, trial on the circumstances in aggravation alleged in the indictment or information shall be bifurcated from the trial of the charges and enhancements. So there's just a zillion questions about what that means. And one of them, I can just deal with one of them out of the billions of them. Must all the aggravating facts be expressly alleged in the accusatory pleading? I think that it's pretty plain that the ones that will go to the jury, whether it's a bifurcated trial or not, and usually the defendant's going to request a bifurcated trial. I think it's pretty plain that those ones do have to be alleged in the accusatory pleading, because it says, upon request of the defendant, trial on the circumstances in aggravation alleged in the indictment or information shall be bifurcated. So I think it pretty much says that they have to be. I am less certain, however, about facts that are admissible to prove or defend against the charged offense or enhancement or otherwise authorized to be admissible by law. I'm less sure about those ones. One of the issues there is whether and how the defendant is entitled to notice of the aggravating facts. Well, I'm sure the defendant is entitled to notice, but when and how is the defendant entitled to notice? So, for example, what if the aggravating facts have been introduced by the defendant in the defendant's case? Or what if the aggravating facts were brought out by the defendant in cross-examination of a prosecution witness? So there's lots of, my suggestion is make as much motions as you can that they should be alleged in the accusatory pleading to give notice and to prepare. Now, a related question is this: can the prosecution amend the information in order to allege those aggravating facts? And when can the prosecution do that? Well, can the prosecution do that on the first day of the trial? Can the prosecution amend in the middle of the trial? The defendant is going to say, I presume, such things as, hey, judge, can't amend at this point. I prepared this whole trial on the information as it stood. Or we're in the middle of the trial. I've been presenting my case on the information as it stood. It's unfair to amend that accusatory pleading. So these are just among the many questions on aggravating facts. Now, I mentioned prior convictions, so that's B3. That the court may consider the defendant's prior convictions without submitting them to the jury. But then it says that does not apply to enhancements imposed on priors. I'm not even sure what that part of that phrase means, so you might as well object to it. Now, I'm going to take questions in a minute here. So the second big change is that certain mitigating factors often are going to require the lower term. Now that's B6, that's buried down in B6. So unless the court finds that aggravating circumstances outweigh such that the lower term is not in the interest of justice, the court shall order the lower term if any of the following was a contributing factor in the offense. There's three of them. The defendant has experienced psychological, physical, childhood trauma, including but not limited to abuse, neglect, exploitation, sexual violence. B is the defendant was under age 26 at the time of the offense. C, prior to or at the time of the offense, the defendant is or was a victim of intimate partner battery, beating up the person you live with, 273.5, or human trafficking. Now, the court can impose the lower term even if there is no evidence of those circumstances. So the general rule that the court can impose the lower term if there's circumstances of mitigation obviously still applies. So one of the questions about these ones is how do you prove that something was a contributing factor? One of these was, so you look at A, for example, the defendant has experienced psychological trauma. Well, look, we've all experienced psychological trauma of some type. How do you prove it was a contributing factor? Well, I've just got one illustration of this here. Suppose the person was under age 26. Well, they committed a crime at under age 26, maybe 19 or 20 or something. How do you prove that their age was a contributing factor? So I found one of the uncodified section 2 of another bill, AB 89. That was a bill, by the way, that raised the minimum age to be a police officer from 18 years to 21 years. Now, why is that important that the age is 21 instead of 18? Well, the legislature, this says in uncodified section 2, has repeatedly relied on neurological research with respect to criminal sentencing law, reflecting a growing understanding that cognitive brain development continues well beyond age 18 and into early adulthood. Scientific evidence on young adult brain development neuroscience shows that certain areas of the brain, particularly those affecting judgment and decision-making, do not develop or do not fully develop, really, I think is more accurate, until the early to the mid-20s. So you've got a case where maybe your youngster had to make a lot of fast judgments, had to make a lot of decisions during the course of this crime. So maybe you can, an expert, maybe based on this particular person, or maybe just in general, can say, hey, at the age this person was at, or at their level of development, their ability to make rapid judgments, their ability to make rapid decisions had not developed or had not fully developed. So that's just one possible way in which you might be able to show that something, that youth was a contributing factor. Now, there's lots of different ways to show this. I just want to open your eyes a little bit to one of the possible ways. Okay, so now another big question about 1170B, is it subdivision B, is it retroactive? The mitigating factors that I just went through. Suppose your client was sentenced before January 1st. I mean, did the crime, got convicted, say in December, has not yet been sentenced in January. Or your client was sentenced and the case is on appeal, but it's not final on appeal. Can they claim the benefit of parts of 1170 subdivision B? Just to mention a few things, I can't dwell on this, there's not enough time, but the ameliorating factors that we just went through, those seem the most likely to be retroactive because they were ameliorating factors. There's no savings clause in all of the 1170 rewritten. There's no savings clause. I got a couple of cases on here. They're also in the written material, Conley and Lara. As to the proof of the aggravating factors beyond a reasonable doubt, there are aspects of that benefit the defendant. Instead of being found by the court by a preponderance of the evidence, now, unless the defendant stipulated to them, they have to be proven beyond a reasonable doubt to the jury or to the court in a court trial. So that's a benefit to the defendant. Probably at least some, depending on the circumstances, depending on the facts, this may be retroactive also. There's a court case called People v. Frost. This, by the way, is not in the written materials. The Frost case, F-R-A-H-S. Just put F-R-A-H-S. There are not a lot of those cases. Just put that in your search find engine and you'll get it. And then Judge Cousins has a treatise on selected changes to California sentencing laws for effective 2022. Many of you probably already have that. You can get it at the First District Appellate Project, but I bet, here's the way I got it. I just put it into Google and out it came. So, and he's got about 4 pages on retroactivity of this, so you can take a look at that. Now, another I'm going to depart from 1170 just for a minute, because you'll remember that I did these 3 new factors. Okay, so those same new factors are also now in new Penal Code Section 1016.7, mitigating factors that the prosecution is required to consider in plea bargaining the case. It's the same. It's our new best friends that the person has experienced psychological, physical, sexual trauma. The person was under age 26 at the time prior to the offense. The person was a victim of intimate partner battering. Prosecutors required to consider them, not required to accept them. So, but how do you approach that one? Well, that one's fairly easy to approach. You say, look, you might want to give your evidence early. You got to make discovery anyway. You might want to give your evidence to the prosecutor to show that you really have the goods on these. You say, look, if you're not going to consider them, or if you're not going to grant them, I'll just prove them up. If my guy gets convicted at trial, I'll just prove them up there, and the judge will have to do it. So let's save that time and expense and turmoil of the trial. Go ahead and give me that plea bargain on that. The other 2 parts of 1170 don't have to directly to do with initial sentencing. So I want to find out, are there any questions so far on this proof of aggravating factors beyond a reasonable doubt, and on those new mitigating factors? And not hearing any questions so far, I'm going to move on. So
there aren't any in the
yes.
chat. I suppose my only question would be, Garrick, there is a lot of language there that says shall and must, but then it's all couched in the most discretionary language possible. So I guess we don't know how that's going to play out yet, or what will have to and have to not be done. But do you have any insight on what that's probably going to look like?
I got pretty much the same insight as you, that there is some unclarity about this. I think the primary unclarity is, do they have to be alleged in the accusatory pleading? What if they come in during the case in chief? What if they were admissible, not admissible? What if they come in, but they're not said to be an aggravating factor? Where's the notice? Gee, I didn't know. I put it into my case in defense. I didn't know it was going to be an aggravating factor. Nobody told me. He says, hey, you had plenty of notice. You introduced it. You must have known. So there's lots of weaselly things like that. And like I said, I would go and try for all the benefits you can, make all the objections you can, and hopefully you win on them all. We're just going to have to find out how this statute works. There was a lot of unclarity. It's kind of full employment for appellate attorneys, really. Make sure you file that notice of appeal, even if if they were sentenced in December. And you still got 60 days, file it, because it might work out on the appeal.
The only other question I have there is, it's you mentioned that there's a trial right for those aggravated circumstances.
Yes.
Does that have to occur after trial or after plea, or can you ask for those aggravated circumstances to be tried prior to the trial in chief? Does it say?
You can ask, but what the statute says is that the trial will be bifurcated. Let's see what it says. Let's see. So it says, upon request of the defendant, trial on the circumstances and aggravation alleged in the indictment or information shall be bifurcated. I have 4 dots there. Let me tell you a little bit of how I write these slides. I try to get the essentials of the language down. Whenever there's dots, you know that there's a lot of extraneous material in there, hems and haws and discretions and so forth, alternate circumstances. I can't remember right now, and I don't want to take the time to look it up. Does the statute say the order, that it must be guilt phase first and then aggravating factors? It probably is. Certainly that's the traditional way that this is done. Now, there's another question too that's similar to this one, and that's this. So you have a jury trial on the main case. Can you then waive jury on the aggravating factors? I feel certain that you can. The statute doesn't say so, but I feel certain that you can do that. Waive jury on those aggravating factors. I'd be surprised if they can be tried first, but heck, it's a brand new law. If you got some reason why you think that's going to help your client, try it. Go ahead and ask. I don't see where it'll do a great deal of harm.
That last
Okay.
sentence is the jury shall not be informed of the bifurcated allegations until there has been a conviction for a felony offense. So there might be an argument. You could try it before. I'll let you get back to it, though. I know you have a lot
Yeah,
of stuff.
sure. Why not? Why not? Okay, so back to where we were. So, okay, this one doesn't come up very much. A juvenile who got life without possibility of parole might be entitled to a rehearing or a resentencing for a new parole hearing or for lower sentence. There are now 2 new mitigating factors. I put 3 new mitigating factors in 1170B, and guess what? They are our new best friends. The defendant has experienced psychological, physical trauma. Defendant was a youth at the time. Defendant was a victim of human trafficking. Okay, now this is an important one. Recall and resentencing has been recodified and expanded. So PC 1170 subdivision D has been repealed in its old form, and there's a lot of lines in your annotated code. You'll see a lot of fines. You'll wonder if it's been repealed. It hasn't been repealed. It's been recodified. It's been put in a brand new section, Penal Code section 1170.03. And the uncodified portions of this law make it plain that it's mainly aimed at lifers or longtime people in prison. There's 35,000 prisoners, many over 50 serving life sentences, but it also does cover lower sentences. In fact, includes specifically people serving county jail felonies. When a defendant's been sentenced to prison or county jail, the court within 120 days on its own motion or at any time on recommendation of the prison, the Board of Parole Hearings, the county jail, the prosecutor, the attorney general, who prosecuted the case, can recall the sentence and resentence the defendant. That's not much different than what came before, except there's an expanded list of 6 different types. Guess who's not in there? The defense attorney. But so there's various ways that the court can reduce the sentence, and the court can consider a wide variety of post-conviction factors. And can also consider, guess what? Here's our 3 new best friends: psychological, physical childhood trauma. They have to be contributors to the offense. Victim of intimate partner battering, was a youth at the time of the offense, and the court has to state it's on the record its reasons. The court can't just say, "Oh, I'm not even going to hold a hearing. I'm going to deny this thing." Denied. No, it has to state on the record its reasons. Resentencing can't be denied, and nor can a stipulation to that be rejected without a hearing. Now, the defendant can appear remotely, but there's got to be a hearing, except for resentencing on the court's own motion. For all these other ones, the prison says it, the prosecution asks for it, there's a presumption that favors recall and resentencing, which can only be overcome if the court finds the defendant is an unreasonable risk of danger to public safety. Now, there's a pilot recall and resentencing program, and Contra Costa is one of the pilot counties, at least according to the San Quentin News. And this is a program that can involve the public defender in it. This is a serious attempt to get some of these long-term prisoners who ought to be out, get them out. The DA's office, for example, can make a contract with a community-based organization, which means that they're contemplating people who are getting out who need help in assistance in adjusting to life on the outside. The public defender can provide input to the DA in various ways. It doesn't expressly say the public defender can say, "Hey, DA, here's this particular person." But I don't see any reason why they can't at least try it. And I don't see any reason why you can't try it. If you know somebody, let's say you got somebody who unfortunately caught one of these life terms, and they've been there for a long time and they're good for resentencing. Talk to the DA, talk to the public defender, see if you can get them to suggest this guy. This program lasts for 3 years, and it's obvious that the legislature is contemplating making this statewide. So take a look at some of your older clients who've been there for a while. See if they maybe are ripe for resentencing on that one. Okay, here's a little one after a couple of tough ones. Nunchucks are no longer illegal. If you got a nunchuck case, you just won it. And if it's not final on appeal, You can write that the way it's been done. PC 16590 is the Penal Code's list of generally prohibited weapons, and item R, a nunchuck, has been taken out of that list. There's no savings clause. This is a retroactive law. Okay, discovery. This is something I'm sure you all know, that PC 1054.2 says that you cannot give to the defendant or to anybody the victim's address, contact information on the victim. You can't give them the address or the telephone number, is what the statute says. You can't give them the address or telephone number. It's a misdemeanor to do so. So there's two changes. First of all, this address or telephone number that you can't give them has now been expanded vastly to you can't give them any personal identifying information, which is defined, we'll get to it, other than the name of the victim or the witness without a showing of good cause. But the misdemeanor has been repealed. The willful violation of this subdivision by an attorney, persons employed by the attorney, or persons appointed by the court is a misdemeanor. I really don't know why it's been repealed. I imagine it's just that the legislature knew that we're all honest, we all abide by the law, and so giving some kind of misdemeanor for this was completely unnecessary. Whatever their reason was, that's out. The personal identifying information has been greatly expanded. It is now what is found in PC 530.55, which is one of the identity theft in the identity theft series of statutes. And then it says, except that it does not include the name, the place of employment, or an equivalent form of identification. Why is place of employment in there? Can I now say, hey, they work down at Joe Blow's bar? I doubt it. I don't know why that's in there. I wouldn't chance it. And what the heck is an equivalent form of identification? Well, there's some 30 express forms in there, the equivalent forms. I would just stick to the name and just leave it at that. It's easiest and probably what's really intended. Okay, there's two new misdemeanors this year. There's actually 4, but I just put in 2. Theft of wages, including intentional deprivation of wages or gratuities, over $950 for one person in a year, $23.50 for 2 or more people in 12 months. It's grand theft. This is really aimed at paycheck theft, or the boss, the employer, shorts people on their paycheck, $1 or $2 every paycheck. It mounts up over time. Or doesn't the restaurant owner doesn't split up the tips properly, keeps too much for the restaurant owner. That's what this kind of thing is aimed at. Now, the other one is a COVID issue, knowingly coming within a specified distance of a person who's on foot, that's one distance, in a car, that's another distance, entering or exiting a vaccine site to obstruct or to harass. It's a misdemeanor, 594.39. However, if you get one of these, the first thing you want to do is find out what the federal courts have done with it, because federal courts have already stayed the operation of 2 parts of these while lawsuits work their way through. So this one may be a dead letter already. If you get a charge, take a look at it. Okay. The Step Forward Act. This is a gang statute. If you do a gang case, this affects you. If you're going to be doing gang cases, this affects you too. So there's lots of changes to the Step Act. They are all reforms. And that's why it's called the Step Forward Act rather than the Step Backward Act. The first one, it adds Penal Code Section 1109. This is in the jury trial section of the code. If a defendant has a gang enhancement, 186.22 subdivision B or D, this adds time to a crime if the crime was done to benefit a gang. And now they have to be bifurcated if on the defendant's request. They have to be bifurcated. And this one, I do have the order down. First, guilt is ascertained, and then if the defendant is found guilty, there's further proceedings on the enhancement. Now, there's also a gang crime in itself, being a gang member. That's 186.22 subdivision A. And this one has to be tried separately from counts that do not have elements requiring gang evidence. Separately, to me, means a different trial, not a bifurcated trial. It can be bifurcated if and go in the same proceeding as the enhancement under B or D. But if it's just A in there and other crimes, you have to have a separate trial on the A from the other crimes. Now, the list of predicate offenses is shortened. In order to prove that this entity is a gang, one of the pieces of proof is that there has to be a certain number of predicate. The gang has to have committed a set number of offenses in the last period of time. The period of time has been changed a little bit. It's now 3 years as defined. The last 3 years as defined before the current crime. On separate occasions by 2 or more persons, and there's been a list of about 31 of these predicate offenses. Looting has been removed, felony vandalism has been removed, 5 identity theft violations have been removed, like theft of a credit card. So it's now only 26 offenses. It goes from E1A to E1Z, 26. And the currently charged offense cannot be used to establish the pattern of gang activity. That's how courts have said, oh, does it say 3? No, just 2. Does it say 2? No, just 1, because we're going to count the current crime. They cannot do that anymore. And the other one is, another one is it says for the benefit of the gang. What does that mean, for the benefit of the gang? Now that benefit has to be more than reputational. What does that mean? So to benefit, promote, or further assist the gang means to provide a benefit to the gang members that is more than reputational. And then this statute, it's in G, 186.22 subdivision G. You got to read all of these statutes. You can't just read the first portion or the first sentence. You got to read them all, because so a lot of times the most important parts are buried in the middle or way down at the end. And here's an example. So what's a common, but more than reputation, may include but not be limited to financial gain or motivation, retaliation, targeting a real or perceived gang rival, or intimidating or silencing a potential current or previous witness or informant. So you used to get the gang expert and they would say, oh, this was a great benefit to the gang because it made everybody in the neighborhood think, what a wonderful gang this is. It benefited their reputation. Now the expert can't say that. Instead, he's got to say, oh, this benefited the gang because it made everybody in the neighborhood afraid to be a witness against the gang. What's your response to that? I think the response is, this isn't talking about making just everybody around be afraid. It's got to be aimed at silencing a particular witness on a particular or concerning a particular case, intimidating particular people for particular purposes, not just, oh, the neighborhood. Well, instead of thinking they're all wonderful, now we're all scared. I think that's your argument. It's got to be particularized. We'll see what the courts do with that one. And the definition of a criminal street gang has been changed. It used to be that a criminal street gang was any ongoing organization or association, and now it's got to be an ongoing organized association. 3 or more persons has one or more of its primary activity is one of these or more of these predicate offenses, common name, common identifying sign or symbol, and whose members collectively, individually has been taken out of that statute, collectively engage in or have engaged in the pattern. I don't think that, so what does it mean? What's the difference between an ongoing organization and an ongoing organized association or organization? I think it's got to be more than a common name or common identifying sign. That's in the statute. It is. The statute's been changed from, but that's been kept in there. So I think that it's got to be more than that. What does it have to be? So there was a letter in the legislative history of this case, a letter from the San Francisco public defender supporting this change in gang membership, because They say that in San Francisco, anybody who lives in a public housing project is deemed to be a gang member. Police testify there's no formal leadership, there's no shot callers, there's no hierarchy, there's no economic organization, there's no initiation process, there's no specific colors or articles of color, code, there's no code of conduct. Just, oh, well, they showed up in a video shooting gang signs, or they showed up on Twitter or something. And so I think this gives us some insight into how to prove, or how the prosecution is going to try to prove, that this was an organized gang. They'll show, oh, there was a formal leadership, there were shot callers, there was a hierarchy, there was economics, there was an initiation process, and so forth. What the defense probably needs to argue for is there has to have been a lot of these. They have to be more formal, not less formal. And the prosecution is going to say, gee, even a hint of maybe one of these is enough to show organization. It's probably going to end up somewhere in the middle. So we're going to see what the courts do with that one. Okay, is this SB 333? That's how you're mainly going to hear about this one, is SB 333. So does this apply to convictions that occurred before January 1st but weren't sentenced till after January 1st? This one, there's a published case on, People versus Lopez. No, yeah, oh, it's published. There is still no official citation on this case. I looked it up just this morning in preparing for this talk, but it's still published. Rehearing was denied on this case just several days ago, that says, yes, this does apply at least to the predicate offenses. It's retroactive. And in that case, the prosecution said, oh, okay, it's retroactive, but we already proved it in other ways. And the court said, wait a minute, you didn't prove that it benefited the gang in a way that was other than reputational. This is a benefit to the defendant, this change, because it makes it harder to prove. And by the way, this changes to the gang law also affect other sentencing, like PC 12022.53, the use a gun or you're done. You get a tougher sentence if you're a gang member. So this applies to that too. Okay, before I go to Re-Codification, any questions on this one? And not hearing any. So Re-Codification of spousal rape. You're going to see throughout the codes, because there's 73 statutes that were changed here, that the spousal rape statute, PC 262, has been repealed. But spousal rape was not repealed. What happened is the spousal rape got folded into general rape. The long time rape statute, PC 261, used to say, not the spouse, with a person not the spouse of the perpetrator. That has now been deleted, so that the spouse of the perpetrator is included in the generic rape statute, PC 261. And so that one, that's how that works. The only exception to that, by the way, is A1, a person because of a mental disability is unable to give consent. That one, it does matter if they're married. And the reason for that exception is so that people with mental disabilities can lead as much of a normal life as possible. They can get married without it being raped like anybody else. So be on the lookout for that one. Okay. Now, Pitcher's discovery can reach back more than 5 years. There's a little bit less than meets the eye to this statute, but it is a step forward, so to speak. Evidence Code Section 1045, subdivision B. You make your Pitcher's motion for peace officer personnel records. The judge decides you've made enough of a showing. He's going to take the records and the custodian of the records back in chambers, look at the records, and give you all those, that ream of records that apply. Well, the statute used to say that information consisting of complaints concerning conduct more than 5 years before the event or transaction that is the subject of the litigation in aid of which discovery is sought. In other words, the judge could say, oh, must say back in chambers, oh, gee, that instance that looks exactly like this case where they beat the heck out of the guy, but look, it's 5 years and 1 month old. I cannot reveal it. Too bad. That is no longer the case in many situations. Now, There's still this weasel word down here in 10452, facts sought to be disclosed that are so remote as to make disclosure of little or no practical benefit. That's still in there, but the judge can no longer say, I've got a 5-year guideline. The judge no longer has a 5-year guideline on what's remote. You have to read PC 832.5 subdivision B to find out what this really means, which says complaints and reports of finding, including all complaints currently in the possession of the department or agency, the police agency, they have to keep records of complaints for no less than 5 years, which has always been the law. They now, however, can keep them for longer than 5 years where there was not a sustained finding of misconduct. Here's how citizen complaints work. The citizen makes a complaint. The peace officer agency investigates that complaint. And if they find it sustained, hey, that really did happen, then there's a personnel, usually there's a personnel action, usually discipline of some type. But if they find, well, it happened, but it was not a violation of policy or law, then it's exonerated. Or they find that didn't happen at all, then it's unfounded. They can also find, gee, we can't tell, which I think they shouldn't be allowed to find, but they can. All right, so it's only if it's a sustained finding that they have to keep it for at least 15 years. So there's a little less than this to meet the eye, but they can still go back 15 years on sustained finding. They're no longer limited to 5 years. So it's been expanded somewhat. Okay, now also read 832.7. 832.7 a couple of years ago was amended so that there were certain egregious police misconduct records that were available through the California Public Records Act, which theoretically meant all you had to do was go in and ask for them. As a practical matter, you're probably going to have to write a letter. You might have to talk to the police officer's attorney. But theoretically, you can get the specified records without going through pitches. This year, that's been expanded by an additional 4 categories. So if you've got a pitches motion in mind, before you file it, before you even write it, read 832.7. It's a very difficult statute to get to see if you can get it easier through the California Public Records Act. Okay, better than Batson Wheeler. This is a potentially a very important law. This law was actually enacted last year. It even said it was effective last year, but it started out by saying that it applies in all jury trials in which jury selection begins on and after January 1, 2022. Why the year delay? It was supposed, I suppose, so that the judges and prosecutors could learn not to be racist or whatever, or it was for the defense to prepare for this thing. So I was supposed to prepare. I might have slacked off on that a little bit. So, and I'm sure none of you did slack off, but just in case, I'm going to go through the whole thing. All right. So a party shall not use a peremptory challenge to remove a prospective juror on the basis of race, ethnicity, gender identity, sexual orientation, national origin, or religious affiliation, or the perceived membership of the prospective juror in any of those groups. There's some defense attorneys who don't like that perceived membership category. I'm not sure why, but if you get that, think about that and what you want to do. But it's an expansion right away of the categories. B, a party or the trial court on its own motion can object to the improper use of a peremptory. Why can the trial court do it? Because the rights that are being vindicated are the right of the prospective juror, the right of the oppressed minority to exercise the full rights of citizenship, including being on a jury. Now, it used to be a 3-step process on this. I make an objection, and then the judge says, what's your prima facie case, counsel? And I have to go into why I think that this was discriminatory challenge, a discriminatory peremptory challenge. Now it's just 2 steps. I make the objection, and the prosecution's got to respond. Now, it can go the other way. The prosecutor can object, and then the defense has to respond. But it's no longer 3 steps, it's 2 steps. And the court has to consider only the reasons actually given and can't speculate or assume other reasons. Another court can't say, well, prosecutor, the reason you gave isn't very good, but you could have kicked them off for this reason, so I'm going to deny that challenge. I'm going to deny the Batson motion, can no longer do that, has to rely on the reasons actually given. Now, if the court determines there is a substantial likelihood that an objectively reasonable person would view race or et cetera as a factor in the peremptory, the objection shall be sustained. That's a complex sentence. The short of it is the court need not find purposeful discrimination, just needs to find that it was a reasonable person would say this was a substantial factor in that challenge. Now, the motion is deemed a sufficient presentation of claims under the US and California Constitution. I don't think I would trust that, particularly not as far as federal courts go. They typically want very specific objections with very specific reasons. And the state courts, I'd go ahead and make your constitutional objections. I wouldn't count on that portion of it. An objectively reasonable person is aware that unconscious bias has resulted in the unfair exclusion of potential jurors. Never mind the fact that half the population has probably never even heard of unconscious discrimination. Nonetheless, an objectively reasonable person is aware of this. I like B. Substantial likelihood means more than a mere possibility, but less than more likely than not. That's a good definition of that. Unconscious bias includes implicit bias and institutional biases. I had to take a course last week to figure out what implicit bias is. I like the definition they gave. They said if it's not expressed bias, but it is bias, then it's implicit bias. That's pretty cool. Institutional bias, well, I'm sure that redlining is institutional bias. There's got to be other kinds that they had in mind. Okay. And a peremptory for any of the following reasons is presumed invalid unless the party exercising it shows by clear and convincing evidence that an objectively reasonable person would view the rationale as unrelated to the prospective juror's race, etc., and that the reasons bear on the prospective juror's ability to be fair and impartial. Now, there's 13 reasons here that are presumed invalid unless that's done. I'm just going to look at number 2, expressing a belief that officers engage in racial profiling or the criminal laws have been enforced in a discriminatory manner. If why did you, I object to prosecutor, why did you challenge that juror? I challenge that juror because he thinks that the police have often engaged in racial profiling. Well, is that a showing by clear and convincing evidence that a reasonable person would view the rationale as unrelated to, gosh, it was a black person who said that, as unrelated to the juror's race, etc. Well, I think it's got to be more than just, oh, I didn't like that, what they said. And then also has to bear on prospective jurors' ability to be fair and impartial. Let's suppose the juror believes that. Let's suppose on these facts, the judge has said, okay, I think a reasonable person would say it's unrelated. Hey, but this is a case with no peace officer witnesses. So their view on police officers got nothing to do with this case. I'm going to grant that Batson motion. Okay, the following reasons have historically been associated with improper discrimination, and so they're presumptively invalid also. So the juror was inattentive, staring back. I didn't like their attitude, their body language. Their answers were confusing. Well, come on, every juror gives confusing answers. Those are presumptively invalid unless the judge confirms it occurred, either because the judge saw it or the objecting party, the defense attorney, well, yeah, judge, they really were sleeping. Then the counsel offering has to show why that demeanor or behavior matter to the case. I think sleeping probably does. I think confusing answer, maybe not. Okay, now on appeal, appellate court also has to rely on the reasons actually given by the judge as well as the opposing party. Can't say, oh, the judge, I didn't like that reason by the judge, but the judge could have done it for this. Can't do that anymore. Got to have the reasons given. The error is deemed prejudicial. If an error is found, it's deemed prejudicial and the judgment gets reversed, remanded for a new trial. None of this, oh yeah, okay, it was discriminatory selection, but the evidence was overwhelming, so it was a harmless error. No. Now, if there was an error. So here's what's going to happen. I predict that the trial judges are going to be thinking, gee whiz, if I erroneously deny this challenge, the appellate court's going to reverse this case, even if the evidence was overwhelming of guilt. And the appellate court's going to think, gee whiz, if I find error here, this case is going to get reversed despite the overwhelming evidence. So I think it's going to make them both more cautious. We're going to see how that one how it plays out. Okay. Any other questions on this? I'm running out of time here. I got a few minutes to go. I was promised an hour, so to speak. We started a little bit after 1. I'm not going to go a lot longer. Any questions so far on this? Not hearing any. Okay. Juvenile justice realignment. I'm going to go over this very quickly because if you do juvenile law, you already know about this. If you don't do juvenile law, you got a lot more to learn than this one. But in 2020, the law said as of July 1, 2021, no more commitments to DEJ, reduced somewhat the age of commitment. Now I have what I'm calling Juvenile Justice Realignment Junior. This became effective on May 14 of last year. And this time they said, hey, we really mean it. DJJ is going to close June 30, 2023. Until then, courts have to consider if the person would have gone to GJJ. They can be placed in a local program, and the counties can establish secure youth treatment facilities for Ward 14 or older who would have gone to DJJ. In that case, the court within 30 days of commitment has to approve an individual rehabilitation program and has to review it every 6 months, can transfer the person to a less restrictive program. And the middle term is the highest allowed for juveniles, cannot give the adult aggravated term. Okay, misdemeanor 1368 treatment is replaced. The statute says it's repealed. It's not really repealed. It's just replaced. If the misdemeanant is incompetent, the court tries to put him in the mental health diversion program 1001.35. If they're not eligible for that, then the court can consider alternatives, modifying any treatment plan that they're in. If your county has Laura's law in place, can implement that. If the person is gravely disabled, can have mental health conservatorship looked into, can dismiss the charge. If the person is on probation, the court will dismiss the revocation charge, but can beef up the terms and conditions of probation. PC 4019. This was the one where there was a case decided yesterday that affects this. So finally, a person who's sent to the state hospital for restoration to sanity treatment gets the good time, work time credits, the normal county jail credits that almost everybody else gets. That's down in amended PC 4019 subdivision A8. And what this is going to do going forward from January 1st forward, if your client's found incompetent, sent to the state hospital, they're going to get those time credits. That cuts back the maximum term of commitment as a practical matter. I think the state hospitals are going to start finding violations of good behavior and work. I think it'll be tougher, but I think it's still a benefit. This statute is not retroactive. A case decided yesterday, I put 15, it was 25 actually. It's called People versus Orellana. It's not yet is not yet final on appeal. Says this is not retroactive. Okay, this is the last really important one that I'm going to discuss. And if you got a client on probation, ever get a client on probation, you need to know this one. So PC 1203.2 is amended to say that if the defendant is in custody pending a formal hearing on violation of probation and not serving flash incarceration, that 10 days that the probation officer can bucket them without going through court, then the court shall, I think that means must, consider release from custody under new section 1203.25. 1203.25 says all releases by a court at or after the initial hearing and prior to a formal violation hearing shall be an own recognizant release unless the court finds by clear and convincing evidence that it shouldn't be doing that. The court has to make an individualized determination. The court can't just have a policy, got to be individual determination and got to state the factors that do and do not indicate by clear and convincing evidence, should or shouldn't, is or isn't a danger, should or shouldn't be released. The court can't use an algorithm-based risk assessment tool in setting the conditions of release. I think they may have meant releasing at all, and I would argue that, but it says conditions. The court has to impose the least restrictive conditions necessary for public protection and to assure the defendant's appearance. Reasonable conditions are all the standard ones, electronic monitoring and so forth, but the defendant shall not bear the expense of any release conditions. So that's going to make it easier for the defendants who get released. Bail shall not be imposed unless the court finds by clear and convincing evidence that that's necessary for public protection and ensuring appearance. But bail is defined as cash bail, not a bail bond, not a property bond. This act has been referred to as the codification of the In re Humphrey case that basically made bail a lot easier to obtain. The court can't deny release on a misdemeanor unless the defendant has a history of disobeying court orders, which can be in the underlying case. Hey, they didn't appear 3 times on the underlying case. The court can't deny release on a felony before a formal revocation hearing unless the court finds by clear and convincing evidence there's no other means available to protect the public and assure the defendant's appearance. Okay, so just a couple of more here. The rape shield law is expanded. This is the law that says that in certain rape cases, evidence of the victim's alleged victim's prior sexual conduct is not admissible unless a sealed affidavit is presented to the court. There's a hearing out of the presence of the jury. The judge finds that this is relevant evidence and it's admissible. Now, the definition of sexual conduct that requires a motion and a sealed affidavit is expanded to include social media. Hey, if the alleged victim's Facebook page says, gee, I had good fun last night, shows a picture of partial nudity or something, that's not admissible unless there's a hearing out of the presence of the jury on a sealed affidavit and the judge finds that it's relevant and admissible. Felony murder resentencing is expanded. I'm not going into this because if you do felony murder resentencings, you already know about this. And if you don't, you have a lot more to learn than this. But felony murder was substantially reformed a couple of years ago, and a lot of people in custody on felony murder are applying for and receiving, in many cases, a resentence to just the underlying crime. This is now expanded to attempted murder and manslaughter, at least those that were tried on a felony murder theory. A couple of years ago, 3-year drug priors were repealed. Were well known as last year. 1-year prison priors were almost entirely repealed, but those laws did not affect the 7,000 people in prison on those enhancements whose case was final when this got enacted. This is now a bill that says the prison has to search for these people, notify the county, the superior court, hey, this is somebody who's got one of these enhancements that is now legally invalid. Please call them back and give them a resentence. Court doesn't have to resentence everybody because maybe they're dangerous, but probably will resentence most of them. There's timetables on this. If you know somebody, bring it to their attention. There's 7,000 people like this in the prison. Electronic filing and serving. There's a new Contra Costa County, Contra Costa Superior Court rule on this, 2.87, but it only applies to civil cases. The reason I've got this in here is for the first time, the California rules of court cover electronic filing, electronic service in criminal cases. They haven't yet changed any local rules. They haven't yet required it, or they've just said, hey, basically what they've said is, hey, this is coming, folks. In the next few years, I believe they are going to increasingly amend these rules to have statewide uniform rules on electronic serving and filing. They don't affect you right now, but this is a good time to look at these rules to kind of get used to what you're going to be having to do in the probably fairly near future. All right, this is the last substantive rule that I'm doing. I'm going to go very fast on this. Many of you might remember that several years ago, the Proposition 57 passed, which said that the prison can write its own sentence reduction rules. And they did so, but nobody could understand them. They were unintelligible. Over the years, they have gradually made them more and more intelligible. They have finally reached a point where even I can understand them. And that took a while. They're on the court's website. go to the prison court's website. They're on the prison's website. Go to the prison, CDCR, put in Proposition 57 in their search engine, and up will pop up a page with a lot of information, including a link to these rules. These are emergency regulations, but I'm expecting them to become final regulations on February 7, unless there's a certificate filed that says, oh, they're no good, they will become final. What they do is they explain in simple, logical terms what each kind of prison credit is, how they are obtained, and how much you can get. Good conduct credit, minimum security credit, milestone completion, rehabilitative achievement, educational merit, extraordinary conduct. Each one is explained in detail in simple, understandable terms. So now, can you calculate how much time your client is going to serve in prison? No, you cannot. Why not? Because they're still too complex. The safest thing to do, even the prison was calculating them wrong for years, and they had to admit it, and they did admit it in facts. Guess what? Those facts were taken down on January 11. I guess they got embarrassed about it. They had to recalculate everybody's credits. The safe thing to do is stick with the statutes. Almost everybody gets the half-time credits, the 50-50, the day for the 6 months for 6 months, ends up day for day for being in the doing their work and behaving. Almost everybody gets those credits. You can lose them if you screw it up. But you can also earn these other optional credits. Talk to your counselor about them. And those will get you out earlier. I think it's kind of dangerous to say, make any better predictions. Okay. Now, answer to the trivia question.
Before you get there, Garrick, sorry, Julia has submitted a question.
Okay.
It says that the new 1370.01 does not state a maximum commitment period, whereas the former 1370.01, the maximum commitment period was 1 year. What effect does this new law have on the maximum commitment period, or is there a commitment period at all? If there is no commitment period, how long can a defendant found incompetent be ordered to participate in the treatment, and can the county treatment provider recommend indefinite outpatient treatment?
Excellent question. Let me say in general, 13.7.01, the statute involved before this amendment, it was one of the hardest statutes in the penal code to read. After this amendment, it is still one of the hardest statutes in the penal code to read. There is a limit in there, but you have to inch through it very, very carefully. I glossed over it, in fact. If mental health diversion is granted, the statute does limit that to 1 year or the maximum term allowed for the underlying charge, whichever is shorter. Now, all of the others end automatically, like the probation. If the judge finds they're incompetent, the judge dismisses the revocation, can change the conditions of probation, but there's a maximum length of probation, 1 year. The Laura's law, that one is a little bit different, where the judge can order somebody to take part in mental health treatment. Not every county has that. I don't know if Contra Costa does. And that one is, there may be the judge can renew these a dismissal obviously is a dismissal. So there is a limit, but you have to read that statute very carefully to find it. Okay, so how many justices might be on the November ballot? 5 might be on that ballot because of expiring terms. There's one position that's open, and if the judge, if the governor fills it, that'll be on the ballot. There might be 2 open. Justice Breyer resigned. Justice Kruger, if I pronounce her name correctly, has been mentioned as a possible replacement on the U.S. Supreme Court. If she's elevated and there's a new replacement justice, that one will be on the ballot too. So it might be 5. I'm beginning to think maybe it's going to be 4, might be 5. Okay. I finished pretty close to an hour. Everybody can get back to court on time. Thank you very much for listening. I will stay for a few minutes to answer any questions. It's been a lot of fun.
Thank you so much, Garrick. It's always a sprint through everything. So everyone, you'll be getting the PowerPoint presentation and that fabulous materials document, which is 109 pages. If you have any questions and have time to stick around, like Garrick said, he is available. Otherwise, thank you all so much for coming, and I hope to see messages from y'all in my inbox about what you want to see next on MCLEs.
And that you'll join Ashley on the board and become a board member for the criminal law section. She needs board members.
I do. I need at least one more.
Not a lot to do, but you need to be in the board. Leadership opportunities. Join Ashley. She's a great leader. Anyway, that's my pitch. Does anybody have any questions? Do we need to hang around?
I don't think so. Everyone seems to be saying thank you and logging out. But if anyone has any questions.
You can email me. My email address is there on the last slide.
Okay.
cbyerslaw@comcast.net.
Okay. All right, everybody. Thanks so much. Get back to court, and we'll see you again in a month. Oh no, every other month.
Every other month.
Yep.
So.
February, January, March. We'll see you in March. There we go. Thanks, everybody. Bye-bye.
Bye-bye.
Thanks, Garrett. Thanks, Ashley.
Cool. Thanks, Anne.
Oh, hey, you're welcome. See you later.